The opinion says that after his discharge, Vermillier called his daughter for transportation and within minutes of leaving the hospital, jumped from a bridge on Highway 613 in Moss Point and died. Now, the plaintiffs allege that inadequate self-deletion assessment, failure to hospitalize him, the premature release, and failure to take reasonable measures to prevent self-harm these factors all contributed to his death. Now, those are allegations from the lawsuit. Okay. Now, the defendants attempted to have the claims dismissed, of course, because they didn't feel like they were culpable and that it was their fault. The Mississippi Supreme Court rejected the dismissal at that stage, concluding that the plaintiffs had stated viable legal claims. It affirmed that the trial court remanded the case to Jackson County Circuit Court for further proceedings on March the 15th of 2018. Now, that ruling did not itself establish liability. So with that all being said, this is a good reason. Now, mind you, this is all my opinion. I'm not stating any of this as fact other than what's contained in the lawsuit. But what I am saying is, and you can see Dr. Hudson's name on here. Okay, he's named as one of the defendants. There are several people. He's the third person named. And this went to the Mississippi Supreme Court. But what I want you to pay attention to is this. I have told you all previously that, in fact, I'm going to read some of the facts of the case, but I have told you all previously that Nolan's parents are going to likely file a wrongful death lawsuit, and as they should. They have every right to. And so, that being said, someone who's already been in the throes of a wrongful death lawsuit, even if they weren't individually blamed, but they were, however, subsequently blamed as part of a group or a whole, a collective. Well, that would be a whole lot of incentive for them to not to want to have to deal with that again. And I'll talk about that in a minute as the reasons as to why they wouldn't want to have to go through that. But here are some of the facts. Vermillier filed a complaint on October the 8th of 2015 and an amended complaint on November the 13th of 2015. Now, according to the amended complaint on October the 12th of 2014, a severely depressed and suicidal Randy Vermillier was standing on the ledge of the Pascagoula River Bridge, threatening to jump to his death. The amended complaint alleged that officers of the Jackson County Sheriff's Office or Sheriff's Department arrived and spent 90 minutes pleading with him. Okay, and so pleading with him to leave the bridge. Now, the amended complaint added Emergency Room Group Ltd. As the defendant. The amended complaint further alleged that when Randy Vermillier finally agreed to step off the bridge, the officers took him into custody and had him transported by ambulance to the emergency room, at Singing River Hospital, where he was evaluated and released after a few hours. So according to the allegations of the amended complaint, Randy Vermillier was evaluated by defendants Jennifer Thomas Taylor, MD, Benjamin W. Hudson, MD, and Aliva Britt, RN. And then he was released from the hospital on his own, without shoes and without hospital employees having contacted any of his family members to inform them of his attempt. Now, the amended complaint alleged that upon his discharge, Randy Vermillier telephoned his daughter, Julie Vermillier Caspi, for transportation. Okay, we already know that part because that was in my summary. So in the amended complaint, Vermillier alleged that the defendant medical providers had a duty to their patient, Randy Vermillier, to exercise such reasonable care and attention as his mental and emotional condition required. Now, Vermillier claimed that the defendants had breached the standard of care by failing to conduct an adequate suicide assessment, because if one had been conducted, Randy Vermillier would not have been discharged from the hospital prematurely. Now, Vermillier claimed that the failure to take adequate measures to assess Randy Vermillier's mental state and keep him hospitalized proximally had caused his suicide immediately after him being discharged. The amended complaint charged the defendants a charge that they had failed to assess and treat Randy, his psychiatric condition, failed to hospitalize him, negligently and prematurely released him from the hospital, failed to take reasonable steps to prevent him from harming himself, failed to follow the standard of care applicable to a depressed and suicidal patient, and failed to inform Teresa Vermillier or Julie Vermillier Caspi of his attempted suicide and need for follow-up care. Now, the amended complaint also alleged that the physician and nurse had failed to recognize the definitive signs and symptoms of Randy Vermillier's medical condition. Vermillion claimed that the Singing River Health System and Emergency Room Group Ltd. Were vicariously liable for the negligent acts and omissions of their employees. Additionally, Julie Vermillion Caspi asserted a claim of intentional infliction of emotional distress based on her having witnessed her father's self-deletion after the defendants had omitted informing her that he had attempted to do so earlier in the day. You know, that's real crazy to me because I don't know why they wouldn't have thought they should tell somebody in the family. Like, that's really crazy. They absolutely should have told someone in the family so they could keep an eye on him. That was negligent. So, Singing River Health System and Jennifer Thomas Taylor, MD, answered and filed a motion to dismiss for failure to state a claim upon which relief could be granted pursuant to Rule 12b-6, the Mississippi Rules of Civil Procedure. Dr. Benjamin Hudson at Emergency Room Group Ltd. filed an answer and a joinder in Singing Rivers and Dr. Thomas Taylor's motion to dismiss. Now, Alva Britt RN filed an answer and affirmative defenses in which she moved to dismiss the amended complaint for failure to state a claim. The defendants asserted that Vermillion had failed to state a claim because under Truttle v. Baptist Memorial Hospital, DeSoto, Inc., 150 SO 3D 692, Mississippi, 2014, recovery against a third party for suicide is permitted only upon proof that the decedent had acted under an irresistible impulse proximately caused by the defendant's intentional conduct that had rendered him unable to discern the nature or consequences of the suicide. Now, because Vermillion's amended complaint alleged negligence, not that the defendants had committed an intentional act that had approximately caused an irresistible impulse in Randy Vermillion to commit suicide, the defendants argued that the amended complaint should be dismissed for failure to state a claim. After a hearing, the trial court denied the motion to dismiss, finding the case to be distinguishable from Truttle. The defendants jointly filed a petition for an interlocutory appeal for the denial of the motion to dismiss. This court granted the petition and stayed the proceedings in court. Now, here's the thing. So basically, they didn't say that they intentionally did anything, that it was on purpose or whatever. They basically just said that they were negligent in failing to assess him and letting anyone in his family know that he was in fact having this episode where he tried to take himself out. And also, let me just say that interlocutory just means that it's a temporary, provisional, or is something that occurs in the middle of a legal act, basically describing the decision or the order or the appeal that is made by the court before the final judgment is reached. So that being said, I have all the reason to believe that, I'm not saying they did anything, but I'm just saying that if something actually had happened and they felt they were going to be responsible, just think back to the Murdaugh case. Okay, just think back to the Murdaugh case. Alex Murdaugh did not want to pay money. He did not want to face those wrongful death lawsuits, and he had every intention of covering it all up, even as going so far as to murder his own wife and son, just to get sympathy, and thinking that if his son was dead, that would be the end of it. But Mallory Beach's family attorney, still sued him. Okay. And like I told y'all, there are a myriad of reasons as to why someone would not want to be involved in a wrongful death lawsuit again. And so let's just talk about some of those reasons. Okay. Now, someone who's already gone through a wrongful death or malpractice lawsuit could have very strong reasons for wanting to avoid ever being involved in another one. Fact of the matter is, it can be financially, draining, financial and insurance consequences. For example, defending a wrongful death or malpractice case can be expensive, even when the physician ultimately prevails. Depending on the circumstances, another claim can also affect malpractice insurance considerations. So if you have already gone through this, and let's just say you get hit with another one, then they may want to cease giving you insurance. Okay, not only could your insurance go up, but they might want to not even cover you anymore. And then there's professional consequences. Certain malpractice payments, made on behalf of an individually named practitioner, those things are to be reported to the Federal National Practitioner Data Bank. Okay, that's known as the NPDB. So think about that. Now this is put out there in this whole data bank where people can see it. And then there's credentialing implications. Hospitals and other authorized healthcare organizations can query, the the NPDB as part of credentialing and professional review decisions. So if you're trying to get a job at another hospital or you want to, work at a clinic or whatever, and they can look these things up and see that, wait a minute, this guy he's had two malpractice lawsuits, or he's been, accused of wrongful charge or named in two wrongful death lawsuits. Think about the repercussions of that. And not to mention the personal stress, depositions, attorneys, discovery, the period of discovery and all of that, expert witnesses. And this could be potentially years of litigation that could make a previous defendant particularly anxious about going through this again, being hit with another lawsuit. So I'm not saying that Dr. Benjamin Hudson did anything shady or anything or whatever. All I'm saying is this. If someone has been hit with a wrongful death lawsuit in their past, they sure do not want to be hit with another one. And that's just the fact of the matter. And they might just be willing to do anything or just about anything to prevent that from happening. Okay? Even including, but not limited to, covering up a crime, okay, that someone close to them may have been involved in that could turn back on them and have them implicated, because they would be held responsible or could be held responsible. Now, mind you, this is just a scenario. I'm not saying any of this happened. Okay, so please pay attention. But does that make sense? Okay, 57 Beige Fox said Doc's running scared. I'm just saying that makes all the sense to me. Okay, I would not think that they would ever want to go through something like that again, and might, in fact, as I said, do anything and everything in their power, to keep from being caught up in this again. And so please pay attention.